Let's start with Prince Andrew. So he has a lawsuit that was filed by one of his accusers, Virginia Giuffre, right? And this was stuff that had happened allegedly a very long time ago, but she filed a lawsuit against him after she already had a settlement agreement with Epstein, Jeffrey Epstein, from 2009, let's say. So I think it was over the summer that she filed this lawsuit against Prince Andrew, and he responded with a motion to dismiss, basically arguing you signed the settlement agreement with Mr. Epstein, and that has an oblique reference to third parties being released. I'm a third party. That should fall, I should fall under that umbrella. So therefore, this should be dismissed. Well, the judge just came back yesterday and said, nope, not going to dismiss it, at least not at this stage anyway. So,
what's the judge's reasoning is the more interesting aspect.
The reasoning was that, yeah. Do you want to share your screen? Because I also have.
Oh, I can. All right. Yeah. Oh, go ahead. Good. Yeah. I'm reading a report from NBC, but if you guys want to see it,
sure.
Let
me
share screen.
I asked because I thought the Prince's argument sounded pretty good, so I'm curious of the judge's reasoning to see if it was persuasive.
It was
because when I read.
Go ahead, Nate.
Oh no, I was just saying because I read through the agreement between her and Epstein, and that agreement really made it clear that anybody kind of associated, like she was getting $500,000 to absolve Epstein and anybody kind of associated with that Epstein crowd from liability. And it was very clear that all these other people. So, unless the judge just say that it was just too ambiguous or something, which I think that's what we're going into. But it seemed very clear that she was gone.
That pulled a lot of weight in this opinion. It was the ambiguity of the 2009 agreement. And part of it, so there's that, and then there's also Florida law saying that in order for a third party in any case to be able to enforce a settlement agreement, they have to have knowledge of that settlement agreement. They have to, there's several restrictions, but one of them is having knowledge of it.
Really?
And where you have have a settlement agreement that has a confidentiality clause saying no one can use this, no one can read this, no one can use this other than the two parties here involved. You have a situation where you cannot say that somebody else knew of that settlement agreement in order to be able to enforce it.
Because you have to break the settlement agreement to use the settlement agreement.
Exactly.
Nice.
Well, exactly. So
I'm not quite sure that.
Although one of the big things that the court said was that this is a situation where the settlement agreement was really not very well drafted. It's very unclearly drafted, particularly having to do with these sections that we're talking about here. And I can understand that sometimes when you're drafting a settlement agreement, if you're a litigator and you're drafting a settlement agreement, you don't necessarily, I don't know, sometimes you're just trying to get the deal done. and you don't necessarily think about these other particular issues, like, oh, what if she were to come back and sue Prince Andrew and these other guys? That may be not necessarily at the forefront of your mind when you're just trying to get this thing hammered out, and especially if it's particularly contentious negotiation between the parties. I do agree with the court that there are some parts here that are pretty ambiguous. And basically, she said that she or he, I can't remember if the judge was male or female. Anyway, the judge said that that where a settlement agreement is ambiguous, the court cannot determine the disambiguity of that, like where the line is between the two arguments. That ultimately comes down to a trier of fact. So therefore, that is not an appropriate argument for a motion to dismiss.
And this basically is this is a pretty basic contract principle that we look at the four corners of the document. In fact, the term four corners is frequently used by the court and in legal arguments presented by whichever side it'll favor to basically say we need to look at the actual text, and you can't read more than the text of the actual contract. And if the contract is not explicit, in that case, it does come down to a trier of fact to determine how the ambiguity should be determined. And that's beyond the purview of the judge. I mean, when we say the court, we mean the judge. The judge doesn't have the jurisdiction to make that determination unless they're sitting sometimes a judge will sit as a trier of fact, meaning they play both roles of trying to decide both fact and law. But frequently, whenever you have a jury trial, the jury is supposed to interpret fact and the judge is supposed to interpret law. You can only interpret law if certain facts are undisputed. But when you have terms in a contract that are ambiguous, unclear, can be read different ways, all this that takes it out of being something that becomes a matter of law. All of a sudden, you start falling into questions of fact, and that makes something you cannot decide on a basis of summary judgment. You need a trier of fact, i.e., the jury, to weigh in and give their determination, and only then can you apply the law based on their finding of fact. So that's essentially how I understand this. That they're saying that it's beyond the ambiguity, as you said, Alita, the lack of clarity now takes it out of the judge's hands and makes us it creates a need to have a trier of fact, i.e., the jury, step in and reach a decision of their own.
Right, that's right, and this is in the I'm looking at the opinion right here, and I'll read one paragraph from it where the judge says exactly that. It says the basic principles of Florida law that govern this aspect of the parties' dispute are clear. Unless contract language is unambiguous and free of conflicting inferences, ambiguity must be resolved as a question of fact. In other words, unless the terms of an agreement leave no reasonable doubt about the intent of the contracting parties, the ambiguity must be resolved by the trier of fact, ordinarily a trial jury. The court may not resolve any such ambiguity on a motion to dismiss the complaint. So here, and the particular ambiguity that the court is talking about is this portion of whether or not this there's a particular provision in the settlement agreement that says that this agreement also releases certain third parties, specifically
any other person or entity who could have been included as a potential defendant.
Yes,
from all or any manner of claims. I mean, that seems pretty broad to me. I'm not sold on this rationale from this court. Because maybe it's because patent law, I deal with this issue all the time about breadth versus ambiguity. Just because a term is broad doesn't mean it's ambiguous.
Well, but let's get they go into some detail. Oh, go ahead, Nate.
No, I just pulled up the settlement agreement, and it's this difference between ambiguous and overly broad. So if the judge said this was overly broad, I would buy that. But being ambiguous, like it says, that she can't. Essentially, it says that from the beginning of time till the signing of this document, she can't really bring any claims against, and both Epstein and anybody related, any other potential defendants, from this. So I don't think it's ambiguous. I do think it's very broad, but I just don't buy the judge's argument that this is just so ambiguous where you can't figure, because essentially he's saying that this is only between her and Epstein. No one else can now use this document to, he's reasoned out all the provisions that for third parties within the settlement agreement.
By the way, that terminology from the beginning of time until the present day is the most common terms used in settlement agreements. Yeah. They almost always say that.
I've written them.
So
in all realities, in all universes, in all
they don't write. I haven't seen that, but yeah,
I have seen it once or twice.
In all universes.
So here's where the opinion kind of goes into detail about why they think that it's ambiguous. They say, so we come to the question of what was meant by the phrase could have been included as a defendant. At one level, of course, literally anyone could have been included as a defendant. If the plaintiff had wished to include anyone else as a defendant, she easily could have done so. Someone can be included as a defendant in a lawsuit simply by including that person's name in the caption of a complaint. Nothing else is required. But neither party takes that position, despite the fact it could be consistent with the literal terms of the 2009 agreement. Rather, defendant argues that he could have been included as a potential defendant in the Florida case because Ms. Giuffre made a general reference to royalty in her Florida complaint, even though it did not name Prince Andrew as a defendant, nor even mention his name. Plaintiff rejoins that Prince Andrew could not have been included as a defendant in the Florida case because, 1, he was not subject to personal jurisdiction there, and in any case, 2, the claims that plaintiff brought against Epstein in the Florida case were based solely on 18 U.S. Code Section 2255, which created a federal civil cause of action in favor of anyone who, while a minor, was injured in consequence of a violation of any of several federal criminal statutes. As to the latter, she contends that Prince Andrew could not have been sued in the Florida case under any of the Section 2255 predicate statutes because there was no basis for doing so. The parties' respective positions show that they agree that the release language, i.e. the phrase could have been included as a defendant, applies only if there is a nexus between the person in question and the claim Ms. Giuffre made against Epstein in the Florida case. They disagree, however, as to the nature of the requisite nexus.
So reading that, I agree with the judge because technically he could not have been a defendant in that case. And that settlement covered all other potential defendants. So if that's the case,
she would be required to have an additional claim against him specifically, and then there would be a question of whether or not Epstein's lawsuit should be properly joined with Prince Andrew's lawsuit, right? If the two have two different causes of action, or two different claims against one another, same fact pattern, but two different claims, two different statutes under which they're being sued, there would have been a legitimate question there as to whether or not those were properly joined together into one lawsuit. The court may have actually tried to split those into two separate lawsuits.